Great. Thank you, everybody. We've been getting a lot of questions in, and as you see, we've really tried to move through this quickly because we want to be able to answer your specific questions. So I am going to try to get to as many as possible and ask certain members of the NELP team to answer. So perhaps the NELP folks who presented, if you could unmute yourself so you'll be ready to go on a moment's notice when I ask you something. I will note we're getting a lot of questions about people with work visas, H-2A, H-2B. In addition, what about people who are victims of domestic violence? VAWA self-petitioners with work authorization. What if someone has a permit they obtained while waiting for the decision on an asylum application, but it's not yet granted? I'm throwing a lot at you, Becky. If you could maybe tell us, and I'm throwing a lot because I know the answer to a lot of these is we don't know yet, but if you could
well, so anyone with work authorization during their base period and now will qualify for regular state unemployment insurance benefits. The question about often H-2A and other temporary visa workers, so DOL put something out now like 30 years ago that said, oh, well, they are able and available, or excuse me, they have work authorization during the base period, but it would be really hard for them to show they're able and available to work during the benefit period. I think, well, I know that there are some, again, individual cases where people took an appeal and were able to convince the judge that since they would have work authorization as soon as they had a job, and I believe I've heard that for some H-2As, they've extended work authorization right now, even though some folks aren't working, you may be able to convince an ALJ that folks are qualifying for, are able and available to work.
And Becky, just quickly, what about folks with T visas? Same thing?
Yeah, I know of a couple of unreported TN cases where folks were found eligible, and then unfortunately we found a couple of TN cases where folks were not found eligible. It really depends on whether your ALJ and your department are looking closely at the DOL guidance to figure out who qualifies, or whether they're gonna accept common sense arguments about people being able to work.
Okay, great, thank you. Michelle Evermore, I'm gonna throw a few questions to you. People are asking, when are these programs going to be up and running, especially PUA? Will there be separate applications, or will the states just automatically process people? I'm wondering if you could sort of give a lay of the land of how we know states are doing, what we think is reasonable in terms of PUA in particular being up and running, and how we think states are going to be operating.
Yeah, so I do know that as soon as legislation looked serious, states had to start reprogramming their computers to be able to deal with this. States, I've heard anywhere from sometime later this week and through early May before states actually have their computer systems reprogrammed to be able to start processing benefits. The key rule I'm sharing with everybody is just look at your state's UI website. Some states are accepting PUA claims right now, even if they're not going to be able to pay benefits for a while. States like Michigan and New York are taking the claims and holding them. Other states are saying, please wait until we tell you that we have our system up and running before you apply. The other thing is it's not terribly clear to us yet if states are going to just roll over benefits from, so first a person has to not qualify for regular unemployment insurance. So we're trying to work with states and we're trying to work with the federal government to clarify that states can just roll that person into PUA consideration without making them go through another step. But that also is not clear to us at this point.
Great, thank you. Maurice, a few folks are asking if you could go into some more detail about the kind of flexibility that states might have in getting PUA up and running. And don't forget to unmute yourself. You're still muted, Maurice.
There
you go.
Okay. That's a really good question, and I wish we had a great answer for that. The guidance just came out from DOL, and interestingly, they just provided a few examples, some of which were pretty narrowly interpreting the law, at least in our view, but they made very clear that the states have flexibility to interpret the law more broadly. So we're very hopeful that the states, especially some of the better states, will do that, and that there's going to be, a lot of interest in getting as many people on this program as possible. But you still have to stick to some of those general criteria, those various categories listed on the slide, listed in the statute, COVID-related reasons for leaving work. And I noticed that, there's some questions about the income, what do you have to earn to qualify for PUA, and that also is very open-ended. It's basically, if you were unemployed, again, even if you didn't have a work history, say you were you're a senior ready to graduate from college, and you were looking for work, you landed that job, and then that job fell through because of COVID. If you did all that, potentially you could still qualify for PUA, even though you didn't have a work history under which you would normally qualify for regular UI. So there's no specific income cutoff, work history required. Obviously, it helps to be able to show the work history. And then a lot of that will figure into what you're entitled to in terms of your benefits. How much you're entitled to in benefits will depend on, what your earnings history look like. And if you didn't have any earnings history, you'll get that minimum benefit that we talked about.
I'm going to call on Brian next. I'm going to read two questions to you that are pretty typical of the kind of things we're getting about independent contractors, gig workers, and Becky, feel free to jump in as well. If we are helping a worker who is clearly misclassified as an independent contractor, but their employer would fight this classification, is there anything we should tell them to do when applying? Should they apply as an independent contractor or an employee if the goal is to get the max benefits as quickly as possible? A similar question, when you say gig workers should qualify for regular UI, what do you mean? In New York, for example, a state that's blue in your diagram, are you saying if they apply for regular UI, they would generally not have an issue with that? Or are you saying they really shouldn't because they are technically employees, but they still do because the state doesn't abide by that well?
Well, I think, to go to the map question. So I think where you're in a state where there is no statutory carve-outs, app-based workers under existing precedent and case law qualify for regular UI as employees. And the advice I would say to that person is to get organized in terms of organizing all your earnings data, because of course part of the problem is that companies don't share that information with the agencies. And if you are in a state that is, as we had in the map, and I believe that map will be shared with people, yellow or red, and there is such a carve-out, and that carve-out includes your occupation as a Uber driver or as a handy worker, that the odds of getting state UI are substantially, if not statutorily, barred. And so in those cases, it's better to apply for the federal PUA.
Becky, anything you want to add?
No, thank you.
Excellent. Michelle, perhaps you have some information on this. We've had a few people ask about gender statistics regarding people who are losing jobs right now. Rebecca spoke about race, but people are wondering about women versus men.
It's a little bit early in the pandemic to really have super reliable statistics about who's applying, much less who's receiving benefits right now. I'm sorry, I wish I had better data, but we will be producing, as soon as we can start to get a handle on that, we will be producing materials on it.
Great, thank you. Let's see. Zach Schiller, you ask, why not try to federalize the whole UI program? We would love to in a perfect world. You can see it's already been hard enough in the first two UI packet, or the first two packages. We haven't been able to get any permanent UI reform in there. So we're going to keep beating away at it and hopefully get there eventually. Maurice, a question for you, California specific. EDD said that PEUC would only apply to individuals that were already receiving UI benefits and were eligible for continuing benefits as of March 29th. Is that correct?
Eligible continuing benefits, anybody, I'm not sure what EDD is saying, but the way it's supposed to work is anybody who who had a benefit year that started after the end of January, ran out of benefits during that benefit year, can collect the extra 13 weeks of benefits. And those benefits will kick in as of the first week of April. So those benefits will be available retroactively. I'd have to go back and look at how EDD's interpreted that, but that's the basic requirement of the law.
Okay, thanks. Bukola, if you could go back to Brian's slide, the state map, folks would like you to just go over that one more time, Brian, and just a little more detail if you could.
Sure. So as I was saying, each state has a different test, a test for employee status. But the point really is that regardless of what they use, app-based workers and gig workers are employees under purposes of UI. We think there's a very strong legal case for that. However, there have been, so let me try to explain this map. So the states in blue are where there is no carve out that would restrict a app worker from being considered an employee. And in that case, they can access state UI. The states in yellow are where there is a carve out of TNC drivers, so Uber drivers, Lyft drivers. And for those cases in those states, those drivers statutorily are barred from receiving UI. And so for them, the federal PUA applies, and the PUA system is how they would be accessing those unemployment benefits. And then the states in red are where marketplace platform workers can't receive UI. So that is the broadest definition of these labor platforms. So it's Uber, Lyft, Handy, DoorDash, your kind of stereotypical gig company in quotes. Workers for those platforms cannot be found to be an employee and therefore cannot receive UI. And for those workers, the federal PUA is how they would access those unemployment benefits.
Great, thank you. Michelle, we are getting a number of questions about multi-state claims, people who have earned income in a variety of states. What should folks do in that situation?
You should always apply in the most recent state that you've worked, and then the states should be able to verify with other states anything that they need to verify. The other thing to keep in, the other question that I'm getting a lot of is if these were all continuous jobs, maybe somebody's working in 3 different places at once, start with the state of your residence.
Michelle, just to follow up on that, what if, for example, the most recent state or the state of your residence has a really, really low maximum benefit, but another state you've worked in has a very high maximum benefit?
That's a tough one. I know that people are being encouraged to shop around and get benefits in the best state possible. I actually heard from a reporter at NPR that somebody applied in Maryland, and the Maryland department said that they should actually go to DC because it's better benefits. All I know is that I've always been counseled to apply in the most recent state, and if you have multiple jobs, it's safest to apply in the state that you live in.
Okay. There are some people pinging in saying they have heard from other sources about looking for where the maximum benefit is. and applying there as well. I think the moral of this story is we're in really uncharted territories right now. And there are some states that have, very high benefit levels, Connecticut and New Jersey, for example, I think in the 700s, and then other states in the mid 200s. So, workers will have to figure out sort of balancing that. Part of the reason why we suggest the most recent is that might be where you have your highest wages. But it certainly can't hurt to Google the states you've worked in what the maximum benefit is and see if that makes more sense as well. Let's see now. Another question. Sorry, there's a lot of things coming in quickly. I worked with college students, most of whom work part-time and may not have worked for 12 to 18 months previous. Are they eligible to apply for UI, or will they need to wait until PUA is rolled out? Michelle or Maurice, do one of you want to take that?
So there's a lot in PUA about monetary eligibility. First, I would say apply for UI, because a person has to not qualify for UI in order to qualify for PUA. So it doesn't hurt to apply now and just realize that you may have to reapply. But the monetary eligibility waivers in PUA are quite significant. And so as long as a person can demonstrate that they've got some attachment to the workforce, there's a high likelihood that they will be able to get PUA.
Great. I'm getting a lot of questions about people who work off the books or got paid in cash only and got paid so little that there wasn't any sort of reporting requirement. What should folks in those situations do?
I can take that one again if nobody else wants it. To the extent that anybody can prove any sort of attachment to the workforce, it's worth trying to get PUA. Every state's going to interpret it differently. And I think that, a lot of these questions that I've been getting for the past couple of weeks about who is eligible and who is not, a huge caveat, I'm not a state UI director. I'm not a state UI agency, and it's going to ultimately be up to them as to who's eligible. My best advice is everybody should apply.
Great. Okay. Let's see. Oh, there's questions about, are furloughed employees eligible for state UI? If not, does that make them eligible for PUA? Lots of questions about terminology, furloughs, layoffs. Michelle, if you want to address that too, that would be great.
Yeah, it doesn't matter if they call it a furlough or a layoff. Anytime your boss tells you that you cannot come to work and they are not paying you, that counts as unemployed for unemployment purposes.
Great. Let's see.
Judy, I just wanted to, George made a correction, and that I wanted to flag, which is that the question about when the benefit year, how far back people could have exhausted regular benefits to qualify for the PEUC program. And I think I incorrectly said the benefit year had to start in August 2019. If their benefit year ended in August, in the end of July 1st, 2019, they would qualify. So I just want to, flag that. That was mentioned in George's comment in the chat.
Great. Technicality question. A lot of people are asking, do you have to be denied for UI in order to then be considered for PUA? Or can you just wait and apply for PUA? I think the answer is going to be, it depends on how the states set up their systems. But if Michelle or Maurice, if either of you want to further elaborate.
So the person, in order to get PUA, you have to not be eligible for UI. So I would assume that the state has to run you through UI consideration before putting you into the PUA bucket. The question is, how simple is that process really? It should be the case that the state takes a look at the claim, realizes it's not a UI claim, but it is a PUA claim, and just makes that determination. And I hope that that's the way that states end up setting things up.
Okay. Are there minimum income thresholds for PUA at all? So for example, if someone just earned 100 in the last year, would they still qualify for PUA, or is that a state decision? Do they need to meet state tenure requirements? Maurice, please elaborate on what I'm about to say if you want to. The whole point of PUA is it's for people who don't qualify for state UI. And one of the main reasons why you would not qualify for state UI is you don't have sufficiently high income in a particular year. You don't have enough to qualify for state UI benefits. You're minimally attached to the workforce, for example. And the whole point of PUA is to capture folks that wouldn't be eligible because of short or irregular work histories. So that person would then be eligible for PUA unless there's another exclusion. If the state normally excludes full-time students, is it up to states to waive that for PUA, or do they qualify for PUA? Maurice, if I could put this to you or Michelle, I think we're still trying to get a grip on what's going to happen with students, right?
Yeah, I think, as I mentioned, I think really the important thing here is going to be, it's not whether you're a student or any category of worker who doesn't have a recent work history, you're not going to be automatically excluded under the state UI rules. That's pretty clear. The question is whether you were, had made that effort to look for work before this whole thing happened, and that ideally you had a job offer on the table. There was a job there that you could not take because of the pandemic. That's the ideal situation. The fact that you were or were not a student, it could figure in if you're not. It could figure in, but basically that's the general rule that is the way it works with disaster unemployment assistance, and we're hoping that's the way it works with the PUA program.
And Maurice, while you're there, could you speak a little bit to work search requirements under both PUA and regular state UI? So for the currently the states were authorized by the federal government to suspend the work search requirements, not blanket, but for if you are unemployed for reasons related to COVID, and then going forward, there is going to be a requirement that there's always the requirement that you're able and available for work. So if you're 100% removed from the labor market, say you have COVID, for example, although under PUA you would qualify for regular UI, you would not qualify because you're not able and available for work. You're indisposed. But in the future, for UI and for PUA purposes, there will be an expectation that you are continually engaged in some kind of work search activity, and that and then there will be some requirement, presumably, that you have to document that. So it's not going away for good, but it's suspended for the time being if you're unemployed for reasons related to COVID. Great, thank you. We're getting a bunch of questions about people that have full-time jobs and then part-time jobs as well. They keep their full-time job, but their part-time job dries up. Are they eligible to apply for anything if they've still got that full-time job? Michelle or Maurice?
Full-time workers are not unemployed, is the short answer. But I think we're seeing a lot of these questions where there's some confusion about people who've worked multiple part-time jobs, and then their hours were reduced such that they're now at much less than full-time. In which case it's going to depend on the state's partial UI benefit. Generally that's somewhere around the worker's benefit eligibility. So if the worker is earning less than their weekly benefit would be, they're often going to be eligible for partial UI.
Great. Lots of questions about people being paid under the table or off the books, so to speak. And what should they do? Is it risky to apply? I think the short answer is yes. It's risky on a number of levels. If somebody is being paid off the books, first of all, there's an employer that probably should have been reporting that all along, paying FICA contributions and employee, payroll taxes and employment taxes, and then the worker, if they were an employee, should have been those income taxes would have been noted on a stub that they should have been paying all along, or if they truly are a self-employed person or a real independent contractor, they should have been filing quarterly tax returns. So generally speaking, it is, I think, a risky proposition for somebody paid off the books to be applying for unemployment. I think there's a lot that could uncover. I don't know that our advice really changes now. You know, every piece of guidance that we've seen, you know, the beginning of it talks a lot about program integrity and fraud, and we'll come after you if you're getting benefits that you shouldn't be getting. I don't know how much bandwidth states are going to have for that in the short term, but we should be careful about how people should be very careful about advising people who've been paid off the books. But, you know, there are other questions about, you know, documentation for people that are going to be eligible for PUA that don't really have W-2s and reported wages, and how can they document that? Maurice, could you speak a little bit more detail about that?
Yeah, and I mean, for disaster unemployment assistance, the expectation is that you will produce some of those documents that Judy was mentioning. In particular, they talk about a tax return. So that's the most common documentation. But if you don't have that documentation, you know, they'll look at pay stubs and other documentation, even potentially an affidavit from the worker. But obviously, that's going to complicate and delay the claim. So that's the basic expectation. Again, you know, the question is going to be, given the massive volumes of claims that the states have to process, are they going to impose all those extra documentation requirements? Are they going to streamline those requirements? Are they going to have presumptive eligibility for people who can document their earnings and wage history on the UI claim, on the claim application? You know, they're struggling with those issues, I'm sure, because they also don't want to have to spend all the time that they normally time validating every claim. But if you have that documentation, at some point it's likely they'll ask for that, and then you can produce it, or other alternative forms of documentation.
Here's a question that is fairly common to a lot of, and this is the last one we're going to be able to answer, unfortunately. And I apologize that we couldn't get to everything. We know there's so many questions and there's still so much coming in. I will reiterate, this entire webinar is going to be made public, and the slides as well. And there's all of the information on our website. And we will continue to be updating people via our unemployment insurance listserv as well, and answering questions when we can. Last question. I have a client whose hours have been reduced because of COVID. He's applied for UI and is receiving partial benefits. He's currently working. He has a child who has asthma. He is worried he will infect his son. He no longer wants to work. Can he apply for full UI benefits? Maurice or Michelle, do you want to answer that one briefly, and then we'll sum up?
Sure. I was just answering a sort of a question in one of these chat questions. So it's not really clear about a family member of somebody who's immunocompromised. It seems clear that was congressional intent, but it's not clear from the guidance. So some of this is going to come down to state interpretation, unfortunately.
All right, with that, folks, I'm afraid we're going to have to end. But we've had over 450 of you on this webinar, and we really appreciate how hard everybody is working to try to get information into the hands of the workers that we're all trying to help. So thank you so much. We will be in touch with more information as we get it. And we just wish all of you the best in these really difficult times. I know everybody's working under very difficult circumstances, and we are grateful for everything you are doing. Thank you so much.